number 35, the people of the state of New York versus Wilkins. Counsel?
May it please the court, may I reserve 2 minutes for rebuttal, please?
2 minutes, sir.
Please. Mr. Wilkins did not impliedly waive his anti-monarchy rights violation when the court first failed to clearly inform him that there had been a violation of his right to be present at the sidebar conferences already conducted. Second, failed to tell him that the options with regard to that violation were for the court to either declare a mistrial, conduct de novo conferences, or for Mr. Wilkins to waive that violation retroactively, and where the court failed to make any inquiry of Mr. Wilkins regarding that violation, what his choices were with respect to those options. The vague statements by the court and prospective-only questions do not provide a basis for this court or any court to find that Mr. Wilkins knew that he was being asked whether he wished to waive retroactively the violation of his right to be present at those conferences. The burden was on the court that had first violated Mr. Wilkins' right to be present at those conferences, and then was told that by the DA to inform Mr. Wilkins of that, and again to inform him of his choices and elicit a response, elicit a choice. Even with respect to the prospective-only question that was asked of Mr. Wilkins, he reserved his right to decide on a case-by-case basis. It was not a blanket waiver going forward, it was not a waiver at all retroactively. The people argue that the failure to object constitutes an implied waiver. The reason that this court has repeatedly rejected an objection requirement in anti-monarchy cases, despite the fact counsel presumably always knows the relevant law, is that the right to be present involved is both fundamental and personal to the defendant. Therefore, this court, over 30 years, or almost 30 years, 29 years.
Mr. Schifrin, in an anti-monarchy case, an implied waiver, there is such a thing as an implied waiver. You understand that?
Absolutely.
All right. And when does an implied waiver apply? What's your understanding of the law, and when would it not apply?
The two cases that I found with implied waiver of the right to be present from this court are People v. Spotsford, cited and relied on by the people, in which first there was an express waiver of an anti-monarchy hearing, but more importantly, relevant here, after the hearing, the court expressly invited an objection, and there was no objection. So unlike this case, Mr. Spotsford was made aware of his choice, and by his silence, it's clear he chose not to object. Similarly,
I'm sorry, did you go ahead?
Does the language that the court used after, I'll read the whole sentence. As to the 4 separate bench conferences, the defendants remained at the counsel table with the prosecutors and defense attorneys present. Is that still the intention of each of the clients? How does that language impact?
I think the reasonable reading of that language is the court is asking prospectively, are you still intending to stay seated? Given the fact that it's undisputed that Mr. Wilkins was not informed before these 4 sentences by the judge, and before the DA pointed out the error that he had a right to be present, that language cannot be reasonably read as requesting of Mr. Wilkins what his decision was with respect to the conferences already conducted. It was easy. The court was asked by the prosecutor, please inform Mr. Wilkins of his right, or the 2 defendants actually, of their rights, and seek a waiver. Rather than do that, rather than clearly inform them that there was a violation of a right already occurred, give them the options and ask for a decision, the court engaged in that, what I refer to as vague language. The Fourth Department, in reversing the co-defendant's case, called that vague language. To find an inferred waiver based on that is very different than Spotsford, where again there's an express invitation for objection. The only other case I found with an implied waiver of the right to be present is Flynn, where again Mr. Flynn was told he was welcome to attend conferences, and he chose not to attend. He was made aware of his option, and his action reflected a decision.
Counselor, I understand that it was easy and it should have been easy, but that's not the situation we have here. So now we have a situation where the juror is still in the box. In fact, the juror is questioned after the antimarchy, right? They're questioning her, they're engaging her. She's in the box. She hasn't left the threshold of the courtroom. Had she left, I would agree with you. But now she's there, subject to questioning, subject to putting things on the record, subject to going back to sidebar. Does that alter your analysis at all?
It doesn't for a few different reasons. First of all, again, Mr. Wilkins was never advised his personal right to engage with respect, we're referring now to juror CK. More importantly, he wasn't present to observe the demeanor and actual tone, etc., of CK during that sidebar conference. He was excluded from. This court has repeatedly, and there's cases cited in our brief at pages 15 and 16, have repeatedly talked about the importance of the personal observation of the defendant. He was deprived of that. He was deprived of that, again, through no fault of his. He wasn't informed by the court. This court, through the anti-North Carolina cases, has made it the court's responsibility, not counsel's responsibility, to make sure a defendant is present unless there's a waiver. That didn't happen here.
I understand that. My only concern, again, and what I'm struggling with, is the fact that she was still there. The defendant would then have an opportunity to gauge, her disposition, to hear her. He's aware now of antimarchy. His attorney is aware of it. The attorney is actually questioning her when she's in the box. She hasn't crossed that threshold outside the courtroom. Are we to say that doesn't, that to sit silently is something that we condone once all the factors are present to make a change in this situation? Under these facts, I understand what you're saying generally, but in this situation, when she's still there.
First of all, this defendant doesn't know the defendant, Mr. Wilkins, doesn't know he's allowed to do anything. He's never told, you can speak. He's never asked his opinion, etc. So there's no gamesmanship on his part, because he doesn't know that there's an antimarchy rule that's reviewable, absent objection, absent showing of specific prejudice. So the personal right of the defendant, which is what antimarchy is about, clearly there was no gamesmanship by him. But in terms of the knowledge, the court presumably knew all that. In this case, not just presumably, was told this by the prosecutor. So there's no reason to find cunning actions by counsel and yet naivete by the court. Having been told by the prosecutor, gee, you should tell him, basically we screwed up, can you tell him his rights and seek a waiver? The court did not do that, did not clearly explain there was a violation. The court did not clearly seek a retroactive waiver. The onus with respect to antimarchy has for all these years has been on the court, not on defense counsel. That's why there's no preservation requirement. Rather than now creating a new objection requirement and applying without notice retroactively to a case tried 4 years ago, the simple rule should be, we have a clear rule with antimarchy. It's easy to follow. We know that because there's only been 8 antimarchy reversals this century, okay, and including that of the co-defendant in this case. If on the rare case that a court is made aware that it made a mistake, the court should then be obligated to correct itself. It's not an obligation on the defendant or the counsel. Counsel had reasonable reliance on this court's jurisprudence that he has no obligation or duty to object. To impose an obligation on the counsel to object when we've been told through many, many cases there is no such obligation is fundamentally unfair to Mr. Wilkins. There was reason to be able to rely on this court's prior rulings.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the court. Your Honors, it's well-settled law that a defendant may waive their antimarchy rights, and that is precisely what happened in this case. Going to appellant counsel's last point, the people are not seeking to impose an obligation on a defendant to affirmatively assert their antimarchy rights. Again, case law is very clear. There is no affirmative obligation to do that. What the people are asserting under the facts of this case is that when a defendant does take actions, those actions can constitute an implied waiver of their antimarchy rights. And in fact, going to Judge Fahey's point, when you really consider antimarchy waivers, every antimarchy waiver is a combination of an explicit waiver and an implied waiver, which is no different than what happened in this case.
You know what I wonder about is it's Mr. Miles, right?
Yes.
Yeah, Mr. Miles, would you see any difference between your argument for an implied waiver under these circumstances? Because there are circumstances in antimarchy jurisprudence where an implied waiver is allowed. But under these circumstances, is there any difference between this type of an implied waiver and a preservation rule requiring you to object? Whether you know about it or not, sometimes things have to be preserved and you have to object. Here you're saying whether you know or not, seems you're saying you have to object, which is just another way of saying you got to preserve the objection.
I understand your point, Your Honor. However, it is a fine distinction, but it is a distinction. We are
Tell me what the distinction is,
Yes.
as you see it.
Yes, Judge. Had the defendant done nothing when it was brought to his attention that that antimarchy had not taken place, that the antimarchy waiver had not taken place, had he done nothing, there would be an antimarchy violation. But by taking affirmative actions, by stating that he wished to continue not going up to the bench, that he understood his antimarchy rights at that point.
But he didn't really say that he understood his antimarchy rights.
Fair enough, Your Honor, yes. He
Right.
didn't explicitly state he understood his rights, but he did assert that he wished to continue as he had been.
You know,
sitting
it's
at
an
the table.
interesting thing. These are essentially fundamental constitutional rights. And it seems that your analysis would rely on a really subtle and thinly sliced reading of the conversation that took place between the defendant and the bench. And I'm wondering if you think it makes sense for us to rely on that kind of a reading in preserving sort of a basic, not sort of, a basic constitutional right.
Well, Your Honor, again, it's clear that the basic constitutional right is a waivable right, and it is one which is waived in the majority of trials.
Sure.
And most cases that make it to this courtroom rely on a fine parsing of the facts of the case as it relates to established law. So in
Counsel,
that-
I'm sorry to interrupt you, but
Yes.
just on this waiver issue and the constitutional right, I thought we said in Vargas that significantly the right to be present at sidebars is not rooted in the Constitution, but rather in CPL 26020.
Yes, Your Honor.
So are we talking about a constitutional waiver here, or are we talking about a waiver of 26020?
There are cases which discuss it in both contexts.
But
There are
Vargas
cases-
was a waiver case, wasn't it?
It was, Your Honor. I believe it was People v. Roman, which made the distinction that the right to be present at sidebar conferences, while the sidebar conferences do represent material stages of trial, that it is not a core function of the trial, it's an ancillary proceeding. So in that sense, I would agree with you and the Vargas court, which stated that it is a statutory right. And again, in that sense, I believe you have to look in each individual case where there is a waiver, you need to look at all of the circumstances. And again, this is a very unique case. The circumstances here are, as far as I'm aware, a case of first impression, where the specific facts.
Let me ask you
Yes.
something. So the appellate division, as I read it, decided the issue regarding juror CK on the ground that the trial court had split the peremptory strikes, and that's the basis of the dissent in the appellate division from Justice Curran as well. They didn't decide on waiver, and you're now asking us to decide on waiver. Why doesn't LaFontaine prevent us from doing that?
Because the appellate division never touched on that. That was argued below at the appellate division, and they never addressed that in their decision. They never addressed that either agreeing with it or disagreeing with it. They didn't address it either way. They said, they simply decided the issue on the grounds that the defendant could not have had any input at that sidebar, and so there was no violation.
But then you're
And they
asking
went
us
through
to
it back.
affirm on a different ground than the appellate division affirmed.
That's correct.
Was there ever any attempt in this trial to reconstruct a sidebar conference, the sidebar conference?
No, I don't believe there was, Your Honor. There was never any request for that type of remedial action by either party. And going back again to just the general world of antimarchy waivers, every antimarchy waiver, rather the typical antimarchy waiver, is an explicit verbal waiver at the beginning of trial.
But you
However-
can impliedly by action, a waiver anti-market rights. Of course, that's when you know that you have that right.
Correct, Your Honor, and which is
You
why-
wouldn't disagree that he didn't know at that point that he had that right. No one had told him that.
At which point, Your Honor?
Well, at the point that the language that was quoted by defense counsel before, the reading of that language itself. Is there any proof in the record that says he knew that he had an antimarchy right then?
Prior to the point where the court informed him of his rights, no, there's no indication that he did, which is why we need to look at his actions at that point and going forward from that point.
Well, it's just, I'm sorry, go ahead, Counselor.
So counsel, I'm sorry, I'm on the screen.
Rivera.
Let me ask you this. If indeed the judge, if the record was clear that the judge said, moving forward, you can come up to the sidebar, you have this right, you would agree then that he has not implicitly waived the prior right or otherwise somehow abandoned his objection to the prior violation, correct? Because the court is focusing prospectively. You would agree if it's obvious that the court is informing a defendant about a prospective right, that one shouldn't take any statement or action to refer to a retroactive waiver? Or do you see it differently?
If the only thing we had to go on was the language of a court making it clear that it was a prospective only right, if that was all we had to go on, then yes, I think we would be constrained to agree that that could not in any way be considered an implied retroactive waiver. However,
Okay, so then if that's the case, if the record is ambiguous and unclear, why wouldn't we read it as not a waiver?
because there is more that we have to go on than just the judge's words. However, the judge's words are indicative of, again, that language of, do you wish to continue what you have been doing? Do you wish to continue not coming up? That indicates that they are looking backwards in time. And the defendant's words and actions going forward from that point indicate that there was a waiver for the sidebars that had already taken place. So we do not just have the judge's words in this case. We have the judge's words, the defendant's words, and the defendant's actions. I see my...
Well, the defendant's words are that I'm going to take it one case at a time. It's not a blanket, yes, moving forward, I defer to my lawyer, right?
That's correct, Your Honor. However, which is why I stated that you have to look at not only his words, but also his actions, and the fact that he did, in fact, stay seated for multiple sidebars going forward from that point. Finally, Your Honors, should the court find that there was not an implied retroactive waiver, it would be the people's position that this is precisely the kind of de minimis violation that the court recognized in People v. Roman does not require reversal.
Thank you, counsel. Counsel, your rebuttal?
Very quickly, first, the statutory right involved here has been referred to repeatedly by this court as fundamental and personal, which is why this court has repeatedly held that no objection is required. The second, and sort of following up with the questions from Judge Rivera, the problem here is twofold. One, there was the initial violation of my client's rights, but when the court was informed of that, the problem is the failure of the court to make clear to the defendant both that his rights were violated and what his options were. He was never, and having not been told of his options, he wasn't asked to select among those options. To now effectively say, well, you didn't do anything, even though you weren't clearly told you could do something, is to, in effect, reward a court for repeated violations of the right to be present. The Roman language just cited by the prosecution refers to cases as de minimis when the defendant's presence could not have made a difference. The defendant's presence could have made a difference here with respect to both prospective jurors, CK and CO. CK was excused because of a preemptory challenge announced by co-defendant's counsel, but under the statute, that's effectively announced by both counsel. There's nothing in the record that shows anything other than the statute was being followed here. The two defendants and the counsel met together after each round of questioning. In fact, the court said you have cumulative 20 preempts. But the opposite is the absurd result that we actually currently have, where the co-defendant's conviction was reversed because his attorney got to announce the preempt and Mr. Wilkins' attorney didn't, and the co-defendant's attorney was able to exercise 11 of the 20 preempts because it went first. That isn't the law. It's not what happened in this case. With respect to CO, CO was removed not for cause on consent, but on consent. In both People v. Danielson and People v. Roman, this court has reversed on antimarchy grounds when jurors have been removed on consent. In Roman, this court made the distinction. In the jurors who were removed for cause on consent, there's no input possible for the defendant. But for the jurors who were removed in Roman for just on consent was reversible error. Over here, CO expressed concerns with respect to the Greece Police Department, a police department not involved in any way or shape in this case. She was never asked whether she could be put those aside in rendering a verdict in this case. There was nothing about her answers demonstrating that she was incapable of rendering a fair and impartial verdict in this case. Therefore, she would not have qualified for a four-cause challenge if one had been made. She was removed on consent. Both defense attorneys expressed their consent prior to the court removing her. So CO, who was removed, by the way, in answer follow-up to a question from Judge Singas, removed prior to any discussion at all about antimarchy, was also a juror who was questioned outside Mr. Wilkins' presence, who Mr. Wilkins' presence could have made a difference.
Counsel, would the error have, Judge DeFiore,
I'm sorry.
Would the error have been cured had the trial judge invited juror CK back to the sidebar, included the defendants and their counsel? Would that have cured the error with respect to this defendant?
With respect to CK, yes.
And recreated that would have cured it?
With
Okay.
respect to CK, there's no question the case law allows for de novo conferences. And again, we urge that CO also was in the same category, but in any event, the problem was the court didn't engage in de novo conference, didn't grant the mistrial, and didn't clearly give the option. And finally, in follow-up to the question from Judge Wilson, I think there is a LaFontaine problem because, again, there was no decision on waiver retroactively with no fact-finding by the trial court in this case. There was no finding in Mr. Wilkins' case. As an aside, in the co-defendant's case, the Fourth Department affirmatively rejected the argument of waiver, saying that the record was too, what the court said was too vague, and prospective-only questioning couldn't support a finding of implied waiver. And therefore, the basis for this court to make a decision on grounds not reached by the courts below is a LaFontaine problem.
Thank you, counsel.
Thank you.